Welcome to the Law Awareness Week at CDC 2024. This webinar is part of Law Awareness Week at CDC 2024. It is a collaboration between Bono SG, the 5 Community Development Councils, National University of Singapore, Faculty of Law, Singapore University of Social Sciences School of Law, Singapore Management University School of Law, the Singapore Corporate Council Association Bono Chapter, and the Singapore Association of Social Workers, supported by the People's Association. I am Yvette Anthony, and I'm your host for this webinar. Today's webinar is on advanced legal planning on wills and end-of-life matters under Sharia law. We are pleased to have the support of the Islamic Religious Council of Singapore, Muis, for this webinar. First, some housekeeping matters. Today, we will be using Pigeonhole Live for our Q&A session. You can submit your questions at any point during the webinar and also upvote on any questions that interest you. If you have a smartphone or a tablet with you, just launch your internet browser and enter www.pigeonhole.at into the address bar. Next, key in our event passcode, which is Law CDC 2410 as shown on the slide. Alternatively, you can click on the link shared in the chat function to launch Pigeonhole Live on your device. If you are viewing this webinar on your desktop or laptop, you should receive an invitation to launch Pigeonhole. Please note that today's discussion is not intended to substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. With that, I would like to introduce our panelists for today's webinar, Halijah Mohammed and Ustaz Kamal Moktar. Halijah graduated from National University of Singapore and was called to the bar in 1984. The focus of her practice is family law in both civil and Sharia courts. She is involved with various NGOs, including AWARE and Muslim Financial Planning Association. She sits in the EXCO of Singapore Association of Women's Lawyers. She is a member of Pro Bono SG's Law Awareness Committee and Muslim Law Practice Committee in the Law Society. She is also part of Musawa, a global movement for equality in Muslim family. She has been involved in representations to Select Committee on several bills, including Administration of Muslim Law Act, Women's Charter, Penal Code, and Maintenance of Parents Act. She contributed the chapter on Overview of Sharia Law in Family Matters in the book Law and Practice of Family Law in Singapore, published by Sweet and Maxwell, 2016. Ustaz Kamal has over 10 years of collective experience in Islamic advisory roles, including holding senior management positions in Islamic education institutions, research, and Sharia advisory roles. He presently holds various positions: Judge, Sharia Appeal Court of Singapore, Associate Member, Fatwa Council of Majlis Ugama Islam Singapore, Muis, Member, Asatiza Recognition Board, Member of Wakaf Masyarakat Singapura Protem Committee, and Member, Singapore Islamic Scholars and Religious Teachers Association, or PERGAS. Halijah and Ustaz Kamal, thank you for joining us today.
Our pleasure.
Thank you.
Perhaps I can start off the discussion, Halijah, with a question that is at the top of our audience's mind, which is, first of all, whether there is a difference between inheritance laws under Islamic principles as compared to civil probate laws. If there are differences, perhaps you could take us through 2 or 3 of the key differences.
Okay, for persons domiciled in Singapore, if he or she dies, right, the distribution of the estate and estate refers to the assets that the deceased leaves behind. Yeah, so we generally call it estate. So the distribution of the estate depends on whether he is a Muslim or a non-Muslim. Now, there is a difference, as you said, Yvette, in the inheritance and estate laws of Muslims and non-Muslims. And before I go further, I want to clarify one thing here. When I talk about Muslim inheritance law or distribution of estate of a deceased Muslim, I am generally talking about the Shafi'i school of law. Okay, very, very simply, Muslims are divided into two groups by and large, yeah? The Shias and the Sunnis. Now, the Sunnis are further subdivided into four groups: the Shafi'i, the Hanafi, Hanbali, and Maliki. So what you guys need to know is that in Singapore, the majority of Muslims are Sunnis and of the Shafi'i school of law. So when I talk about the distribution and inheritance laws for Muslims in Singapore, I'm talking about the Shafi'i school of law, yeah? There are slight differences with the other school of law, but I'm just focusing on, because the majority of Muslims in Singapore are Shafi'i, yeah? Okay, so first, for non-Muslim, if he or she dies, non-Muslims, there is freedom of disposition of his estate, i.e., he is allowed by the law to distribute his estate to whoever and in whatever shares or portion he wishes. So, for example, a husband dies, he leaves behind his wife and two sons. But in his will, he stated that my entire estate, 100% of my estate, I am giving to my wife, nothing for my two sons. That is allowed for non-Muslims. Another example, right? Husband dies, leaving behind his wife and maybe, like I said, the two sons, elder son, younger son. And in his will, he stated that I am giving 80% of my estate to my elder son, nothing to my younger son, and 20% to my wife. Again, this is allowed. Or another extreme example, a man, right? He gives away the entire estate or the bulk of his estate to his mistress, for example. But so this is generally allowed for non-Muslim, largely because we have this concept of complete testamentary disposition for non-Muslim. Okay? So you can will away to whoever, whatever you want. Now, for Muslims, this is not allowed. So Muslims, you can do a will, right? But unlike non-Muslims, your will is limited to only 1/3 of your estate. So for example, deceased has $1 million worth of estate, yeah? Banks and property, etc. What he can do if he wants to will away part of it, he can only will away 1/3, i.e. 33%, i.e. 330,000 worth of his estate to whoever he wishes to. Okay? So what is the difference? First one, Muslims can only will away 1/3. Non-Muslims, you can will away 100%, 2/3, 70%, whatever. Okay? So that's one big difference. Right? The second difference is this. If a non-Muslim dies, yeah, what will happen to his estate? Okay? And he doesn't have a will. Just now I explained, right? Both Muslims and non-Muslims, you can do a will, but for Muslims, limited to 1/3. So for non-Muslims, if he doesn't have a will, and you know, a lot of people die without a will, yeah, which is sad because you really should do have a will, right? So if a non-Muslim dies without a will, his estate will be distributed according to this law in Singapore called the Intestate Succession Act. We call it the ISA. And the ISA lays down, it is specified by law, who will inherit his estate because he doesn't have a will. So, for example, I just give some examples so that the picture is clear. A husband dies and he leaves behind his wife and they have no children, or he has no children from previous marriages. So in this case, the Intestate Succession Act says that 100% of the estate will go to the wife. This is by law, yeah? Because he didn't have a will. Or another example, husband dies, he leaves behind his wife and 2 children. The ISA says that 50% of his estate goes to his wife and 50% will be divided equally between his 2 children. Okay, another example, right? Husband dies, he leaves behind no wife, but 2 children. ISA states that 100% of his estate will go to the 2 children. They will share equally. Or another example, husband dies, he leaves behind his wife, he doesn't have any children, but both his parents are alive and around, survive him, right? So the Intestate Succession Act says that his wife will get 50% of his estate and his parents will get the balance 50% divided by 2. So what is the difference between Muslim and non-Muslim? The Intestate Succession Act does not apply to Muslim. Okay? So the Intestate Succession Act is only for non-Muslims who die without a will. So what happened to Muslims? So if they die and they have no will, remember, they can will away maximum of 1/3. So let's say there's no will. So where does 100% of the estate of this deceased Muslim go to? So it will be distributed according to Muslim law, i.e. Faraidh, F-A-R-A-I-D, yeah? You can Google this, F-A-R-A-I-D laws. And Faraidh laws, it defines and determines who are your beneficiaries, your heirs, S-H-E-I-R-S, not A-I-R, H-E-I-R-S. So Faraidh determines who are your beneficiaries and what is their specific share. So if you die, Muslim dies without a will, that the 100% will be distributed according to Faraidh laws. If he dies with a will, remember 1/3, he can will away. The fixed 2/3, yeah, the balance 2/3, he cannot do anything about it. It will be, by law, it will be distributed according to Faraidh laws, right? Okay, I will give some example because this is quite an important point, right? For example, under Faraidh laws, yeah, husband dies, he leaves behind his wife and 2 sons. So under Faraidh law, the wife will get 1/8 of his estate, 1/8, and the rest, right, the 9/8 will be divided equally between his 2 sons. Another example, yeah? Husband dies, he leaves behind his wife and 1 daughter. Now, in this particular case, there is no male heir. He leaves behind his wife and a daughter. So what is the distribution according to Faraidh? It will be 1/8 to his wife, 1/2 to his daughter, and 3/8 will go to Baitul Mal. Now, what is Baitul Mal? Baitul Mal is like a Muslim treasury in Singapore. In Singapore, it is administered by the Muslim Religious Council of Singapore. So you will see, right? So man dies, leaving behind his wife and a daughter. The wife will get 1/8, the daughter will get 1/2, and the 3/8 will go to Baitul Mal. Okay? Another example. A wife dies, right? Leaving behind her husband with 2 sons. What does the husband get? 1/4 goes to the husband, and the rest, right? The balance, 3/4 will be divided between the 2 sons equally. I'll give another example. So the point I'm trying to explain is that these Faraidh laws, it identifies who are the beneficiary. For example, is it the Muslim treasury, Baitul Mal? Is it the wife? Is it the daughter? Is it the son? And what is the specific share? So I give another example, right? For example, a person dies, leaving behind only 3 sisters. He has no wife, he's got no children, his parents are not around. So this man dies, he leaves behind 3 sisters. So what does Faraidh says, according to the Shafi'i school? 2/3 will go to the 3 sisters equally, and the rest will go to Baitul Mal. Okay, so the point I'm going on and on about how this is divided is because the Faraidh law determines who are the heirs or beneficiaries and the share. So in Singapore, what happens? Suppose I die, right? Then how do my next of kin know who are my Faraidh beneficiary? What do you do? So the next of kin will have to make an application in the Sharia court, not in the civil court, yeah? Sharia court. And Sharia court will issue a certificate of inheritance which identify who are my Faraidh beneficiaries. So this application is made at the Sharia court portal, and then based on what is the input that my next of kin put in, so the question will ask, is there a husband? Is there a son? Is there a daughter? Is there father? Is there mother? Is there brother? Etc. etc. And then based on the input that the next of kin put right in the application, the certificate of inheritance will be issued by the Sharia court. Now, before I go on to something else, I want to point out this, and a lot of people don't know this. And the question, they say, why is it that for Muslim law, the 2/3 is fixed, that you cannot maneuver, you cannot do anything, it's fixed by law. So what happens if I say don't like my elder son, okay? Or I prefer my youngest daughter, or whatever. You see, we mustn't misunderstand. This fixed as, or they call it in law, mandatory or compulsory heirs or beneficiaries. This law is not unique to Muslim law. In countries with civil law jurisdictions, Brazil, Italy, Germany, Switzerland, Monaco, Japan. So the civil law jurisdiction, Singapore is a common law jurisdiction, but I will not confuse you all. So civil law jurisdiction, they also have the concept of mandatory heirs. So I think in Switzerland, half of your estate, you cannot will away. It must be given to certain surviving relatives. Yeah. So this concept of mandatory beneficiaries or compulsory heirs, right? It is not unique to Muslim law. Other jurisdiction has it because they believe that certain compulsory shares of the deceased estate must be inherited by certain surviving relatives. Because the idea is your nearest is your dearest, and your dependents need your estate, etc., etc. Okay, so that is in so far as the Faraidh is concerned. I want to point out one thing before I give back the mic. The will of a Muslim estate, you cannot enlarge in your will the shares of any of your Faraidh beneficiaries. So for example, I gave the example just now, right? A husband dies, leaving behind his wife, one son, one daughter. Okay, so what happened is the wife will get 1/8 of his estate, 7/12 will go to the son, and 7/24 will go to the daughter, because daughter gets half the share of son. Now, supposing the deceased, right? He says, no, I want to give my daughter more. I want her to get the same as my son. And I put it in my will. Remember the 1/3? Now, this is not allowed, right? This is prohibited. You cannot put in your will Faraidh beneficiaries, or you extend or reduce the share of each Faraidh beneficiary. You can give it to other people. For example, you want to give it to mosque, the will, your 1/3 will, to mosque, maybe to orphanage, right? Maybe to your best friend, etc., etc., but not to your Faraidh beneficiary. I think I have to, it's a lot to digest, so I will stop. Yeah.
Thank you very much for that overview, Halijah. I think that was very helpful. So if I just recap, from what I understand, there is freedom of disposition under Faraidh for up to 1/3 of the estate, right? So maximum of 1/3 can be given away. That means that there must be some amount of planning that can be done before the end of life. And so with that, perhaps I'll invite Ustaz to share with us whether this concept of planning is consistent with Islamic teachings and principles.
All right, thank you very much, Yvette, and thank you for having me today. Planning is actually very key. So as we say, if you don't plan, you are planning to fail. So with regards to wealth, there are various stages in accumulating our wealth. So when a person wants to accumulate their wealth, first thing is that we call it the wealth creation. That's the first stage. Then after that, we talk about wealth accumulation, and then we talk about wealth protection, and then the fourth stage is wealth purification. Last stage will be wealth distribution. So for people who have wealth, they must ensure that the wealth that they have accumulated should be distributed to the people that are meant in the loved ones and people who are important in their lives. So basically, for anybody, okay, before anything happens, there must be a form of planning to ensure that there's no disputes between the family members, and there's no oppression, and the wealth is distributed correctly according to Islam. If there's any dispute whereby a person distribute the wealth wrongly, then it will be considered as null and void. All right. So first thing, when you want to distribute your wealth, you must recognize, you must remember that the wealth must follow a certain ranking before Faraidh law comes in or kicks in. Okay, first thing is that the person knows that the first thing that he has to plan is funeral expenses. So even how he should be cleansed, which company should manage his funerals, there should be a form of planning. All right. And secondly is actually the we call it the clearance of debts. Okay, the clearance of debts. Whether they have debts with other persons, if they have taken interest-free loan from friends. Okay, when we talk about organization, banks, I think banks, they know how to clear the debts. They have collaterals and they have charges and so on. You don't have to worry about those debts. But when we talk about personal debts, these debts have to be cleared with, if it's taken from family members, from friends, it must be cleared. And also debts in the religion, debts with God. If somebody has not performed the Hajj and he has affordability in performing the Hajj, so he needs to set aside certain amount of monies so that somebody can perform the Hajj on their behalf. And if they have certain debts, which in terms of zakat is the yearly tithe, where yearly portion that they have to distribute to the 8 asnafs, then they have to, if they have not paid it, or for the past few years they have not paid, is considered as debts, then they have to set aside the monies in the payment of these debts. And also if they have not fasted, they miss the fasting, and they need to pay the fidya and so on, or even some kafara, these monies have to be set aside in the payment of the debts. Thirdly, then we talk about will. Just now, I think Halijah have spoken quite lengthily about wills. But wills, if somebody have made it 1/3 other than the beneficiaries, then is considered as will which is considered as valid. And this will has to be implemented first. The monies have to be set aside first. If let's say just now Halijah says about 1 million, right? 1 million, then 33% have to be set aside for the implementation of the wills. Whether you want to give to the mosque, or now we have wakaf masyarakat, I think it's a very good program, and we can consider giving aside this wakaf for the future usage of all our religious institutions as well as our scholars and to ensure that this legacy can carry on. And lastly, then we talk about Faraidh. Faraidh is the distribution which Cik Halijah has mentioned. It is obligatory. Allah Subhanahu Wa Taala in the Quran has mentioned in one special chapter called the chapter on women. Okay, it's a specialist chapter to talk about all the rules and regulations with regards to upholding the status and the position of women in Islam. All right, so in terms of distribution of Faraidh, the Quran states, "Yusikumullahu fi auladikum." Okay, so that the distribution is fair. Okay, so God have said in the Quran, He stated that we have ordained upon you in terms of wealth distribution to your children. And also, we should not be excessive in terms of giving away our wealth, because there was once instance whereby a companion called Sa'ad ibn Abi Waqqas, he is a wealthy person. So he came to the Prophet sallallahu alaihi wasallam, peace be upon him, and he said, "O Prophet, I have a lot of wealth and I have only one daughter to inherit my wealth. So can I give away my wealth, whole of my wealth to other people? And the Prophet said, no. And then he says, half of it? He says, no. And he says, about 1/3. And he says, even 1/3 is too much. And the Prophet says, antadhara warathataka aghniya khairun laka min antadhara hum alatan yatakaffafuna finnas. And the Prophet says, it is better for you to leave your children rich instead of leaving them in needs from other people and asking other people to fulfill their daily needs. So these are certain rules and regulations that we have to follow to ensure that the beneficiaries will get the wealth that we have accumulated. Because basically, when we accumulate wealth, it is to ensure that our family members will live well. Okay, and so when we talk about Faraidh, we talk about the beneficiaries. The main beneficiaries in terms of Faraidh, we have 5 people in which must receive the wealth that we have. And in the religious term, we call it the Ashabul Furud, the people that is obligatory to receive our wealth. Between husband and wife, if the husband dies, then the wife must be a beneficiary. And then the parents, okay, the parents, the father and the mother, and then the children. So these are the 5 main people that will receive the wealth of the dead person. So and Islam has determined the various proportion, and I think Cik Halijah has already mentioned the proportion with regards to the wife, the proportion with regards to the husband, proportion to the father and the mother, and then the proportion to the children. We call it the hasabah. When you have a son, the son will block all other relatives. Okay, all other relatives from receiving the distribution of the faraid, and the son and the daughters will receive the balance. Okay, will receive the balance, and the son will receive 2 portions, and the daughters will receive 1 portion. And some of us might question why Islam gives priority to the sons. All right, so this question might come up. Because in the first place, when the daughters receive 1 portion, it's actually huge for them. Okay, it's a big portion for them, because for daughters, the money is for them to use for their use alone. Okay, so if let's say a daughter receive and he has a husband, the husband has no business in asking how much do you receive in terms of inheritance. It's for her to spend. But when the sons, normally the sons have families. So I have a family. So whatever inheritance that I receive, if I receive any inheritance, I have to use it for my wife or expenses and for my children. So the 2 portion is actually to be shared by a lot of people. All right. But for the daughters, it is for them. All right. And I think that 1 portion is actually more than the sons in terms of in terms of the usage of the money, in terms of calculation. So these are the ways in which the wealth should be distributed. But in Singapore, we have a unique way of distribution. Other than Faraidh, we have other instruments that we use. Okay, so we call it the nomination. Okay, and we call it in terms of certain assets that we have in Singapore, in terms of property. Okay, in terms of property, if we have HDB estates or we have houses, in Singapore, we have a unique law, because this is to solve the problems of our community. So in terms of our property, we follow the law of survivorship. So if we sign a contract based on joint tenancy, if the husband dies, then the house will be passed on to the wife. And if the wife dies, then the house will be passed to the husband. Simple, straightforward. And also we have a unique way of distribution in terms of our CPF. Our CPF is based on nomination. So if let's say we want to distribute our CPF monies, we can distribute as and how we like to distribute it. If you want to give 100% to the wife will receive it. If you want to give to anybody according to the proportion and the fractions, they will receive according to the fractions that we have determined. So I think I'll stop here. Maybe we have some other issues.
Thanks very much, Ustaz. And Thanks very much, Halijah, for your earlier responses. So now that we understand the differences between Sharia and civil probate law, and now that we understand also that the concept of planning is in line with Islamic principles, I think the next question that comes to mind is a fairly fundamental one, which is that who actually implements Faraidh law, and how would the person or the body that implements Faraidh law, how will they know the net worth of the deceased? I'll open this question up to either one of you.
Okay, okay. No, the institution doesn't implement, no institution, whether it's Sharia court or what, implements the Faraidh law, right? So basically, let's say Ahmad passes away, right? Ahmad leaves behind his wife and his 2 sons. And Ahmad has a HDB flat, he has bank accounts, he has CPF money. So the first thing that the next of kin, his wife or his children have to do is, like I said, apply for the certificate of inheritance from the Sharia court. Now, this is assuming Ahmad did not have any will. So then what will happen is, after getting that certificate of inheritance from the Sharia court, the administrators, in this case will probably be the wife and the son, assuming there's no minor children. The administrators will then have to make an application in the family justice court. Yeah. This is called the probate or the letters of administration process. Now, there's no difference whether you're a Muslim or a non-Muslim. You still have to go to the civil court to get your grant of probate if there is a will. Remember, Muslims can do will, 1/3 will, and in the will you can name who are going to be your executors, right? And if there is no will, you have to apply for letters of administration so that the court will appoint administrators, and these administrators or the executors, right, will then distribute the estate of Ahmad, right, according to Faraidh laws. So in terms of, to answer your question, the implementation is done by human beings, who are either the executors if there is a will, or administrators if there is no will. So who appoints them? The court will give a grant of letters of administration to the administrators, or a grant of probate to the executors if there is a will. Because if there's a will, usually you identify who is going to be your executor. But for Muslims, the only difference between Muslims and non-Muslims is this. For Muslims, you have to take a prior step before going to apply for your grant of probate or letters of administration. You have to go and apply for your certificate of inheritance from the Sharia court to identify, right, who are the Faraidh beneficiaries. So this certificate of inheritance must be attached to your application for probate or letters of administration. So the person in the grant, right, of letters of administration or in the grant of probate, in Ahmad's case, probably his wife and 1 son, they will then take control of Ahmad's estate, right, and then distribute it according to Faraidh laws. So, for example, liquidate the bank account, liquidate his share portfolio, and if there is other properties in his other asset in his sole name, that will then have to be distributed according to Faraidh. Because in this case, I'm assuming there is no will. And of course, if there is a will, whoever are the executors, after you get that grant of probate from the civil court, you will then administer the estate, distribute to whoever are the beneficiaries under the 1/3 will, and the balance 2/3 according to the Faraidh beneficiaries, according to the certificate of inheritance.
Okay.
Maybe can I
That's
add a bit?
Yes.
With regards to distribution of wealth, generally, if death happens in the family, suddenly everybody knows about Islamic law. Okay, it is not, it's a norm. Suddenly, the wife knows everything about Faraidh, the rules and regulation. The sons will know. Even everybody, even though they have no prior knowledge about Islamic law and they do not practice Islam, but when death happens, everybody knows about
They
how
want to make
they rise.
certificate
Yes,
of certificate of inheritance.
Yeah.
They want to know, right?
Yeah.
What is my share, after
Yeah.
the Faraidh? Yes. Yeah.
So suddenly everybody knows about rules and regulations. Oh, I know this is how Islam should go, and I want to implement it because I have this rights. Okay. So when somebody dies, generally in practice, the distribution of wealth is actually very specified. Because in terms of wealth, the main asset that we have is actually the house. The house is based on joint tenancy. So if husband dies immediately, automatically the wife will own the house. So actually that's a big chunk of the wealth. And then another big chunk will be the CPF monies. So the husband before anything happens, he has nominated the wife or whoever he wants to nominate, and based on CPF law, within 14 business days, these monies will be sent out to everyone who has been nominated. And if he has death benefits, insurance policies, death benefits, it's also based on nomination. So if let's say he has nominated the wife will get the wealth. So generally, most of the monies is actually distributed not based on Faraidh. All right. And even if he has a bank account, and the bank account is actually joint account between the husband and the wife, then the wife will own the joint account. So now we are talking about the rest of the wealth that is owned by the husband. If he has other properties, business, and so on, this wealth will be distributed according to the Faraidh. And in terms of the amount, generally the head of the family would distribute it accordingly lah. Because in terms of the proportion, even the family out of the immediate family, the uncles, the aunties, they will give advice on how to distribute, and we can calculate on our own. If we don't get the certificate from Sharia court, then we can actually calculate the portions in the website, the inheritance calculator, and we'll know what are the proportions that should be distributed to the different members of the family. Yeah.
Thanks very much, Ustaz and Halijah. It's good that you brought up the realities of what happens when someone passes away, because that's a good segue into another issue that I think our audience is very interested in learning about, which is that increasingly we are seeing a number of non-traditional family units where parties may have gotten married under the civil law system and then subsequently reverted to Islam. Or alternatively, sometimes there may be adoptive children, and some members of the family may not have reverted to Islam. And in that scenario, would the 1/3 portion of the estate be reserved for only members of the family who have reverted to Islam? And I think the second related question is, what about in situations where parties got married under a civil law system and then subsequently embraced Islam?
Okay, I think the first thing that we need to know is this, yeah? The Faraidh beneficiaries, right? They have to be Muslim, yeah? A non-Muslim cannot be a Faraidh beneficiary. So, if, for example, a Muslim man married a convert, okay? He married a Christian, and she then converted to Islam, okay? Then she dies. Yeah, unfortunately, she dies. So, but she has dependent parents. Okay, just because she converted to Islam doesn't mean that her aged parents, right, are not dependent on her. So, what happens in this situation, right? Because she is a convert and her parents are not Muslims, they cannot be her Faraidh beneficiaries. They are her immediate family, right? But because they are non-Muslim, they cannot be a Faraidh beneficiary. So what will happen in this case is the non-Muslim parents of the deceased, the lady, right? She was a Christian, she has now converted, but her parents are non-Muslim. So if she wants to ensure that her parents receive something from her estate, then she must do a will and she must identify her parents to receive 1/3 of her asset. So for example, I gave the example of $1 million. So this originally she was a Christian, this lady, and she has converted and she passes on, right? And she leaves behind her husband, her children, and her aged parents who are non-Muslim. So in her will, she must specify that 1/3 of her asset, 330,000 worth of asset, should be distributed to her two parents who are non-Muslim. Okay, this is just one example. Now, another example is if you have adopted children. Under Faraidh laws, adopted children cannot inherit. Okay, the inheritance under Faraidh laws is based on it must be biological connection, biological children, or by marriage. Yeah. So adopted children is not one of the compulsory or mandatory heirs. Yeah. So they're not. Then what happened? So you have an adopted children whom you love very much as your biological children. So what do? In your will, again, the estate of this guy who died, leaving behind $1 million worth of assets. So he should specify in his will that 1/3, 330,000 of my asset will go to my adopted son. Okay, so these are or step children, right? People marry, they get divorced, and then they have children from previous marriage, and then they have another marriage. This is common, yeah. So if you have been looking after your stepchildren and you have been loving and bringing up your stepchildren as much as your own biological children, now stepchildren are not, they are not one of the Faraidh beneficiaries. They're not. They are outside the Faraidh beneficiaries. So what do? Again, you have the freedom, right? You have that flexibility to will away 1/3 of your asset. 33% of my 1 million will go to my stepchildren. So this is part of estate planning, like what Ustad was explaining just now. So we have to be mindful that if you don't have a will, so for example, my example of this lady who was originally a Christian, she converted to Islam and then she passed on, but she has parents who are dependent on her. So if she doesn't do estate planning, right? If she doesn't do a will, then her parents who are non-Muslim will get nothing, because her parents who are non-Muslim will not be her Faraidh beneficiaries. So it is imperative that she prepares a will, giving away whatever that 1/3 share. She may want to give the entire 1/3 share to her parents, because 2/3 of her estate, right? 2/3 of the estate will be Faraidh beneficiaries, i.e. her Muslim husband and her Muslim children, and so on and so forth, like in the example of adopted children, stepchildren.
Understand. Thanks very much, Halijah, for that explanation. And I think still on the topic of flexibility and the ability to maneuver around the Faraidh rules, I think another question that comes to mind in this day and age is the issue of prenup agreements. So the first question is, are they enforceable generally? And second of all, can they be used in any way to ring fence assets ahead of time, to change the distribution or limit the applicability of Faraidh principles in any way?
Okay, when you talk about prenuptial, because of the word nuptial, it is always related to marriage and divorce. It's got nothing to do with death. Estate and inheritance is when somebody has pop off, right? Or pass on, or demise. So prenuptial is usually an agreement, right? Entered into between husband and wife before the marriage, right? To protect certain, for example, a very, very simple example would be, I am a billionaire, okay? Or a trillionaire. And then I marry someone who doesn't have that kind of wealth. So I want to protect my assets, which I have acquired before I even knew this girl existed and I married her. So that's the purpose of a prenup. The prenup will state that upon divorce, right, whatever are my assets before I know you or premarital assets will not be divided but it's upon divorce. Okay, I'm putting this simply, very, very simply. There are laws about whether prenup will be upheld by the court and all that, but we are not here to discuss all that, right? But to answer your question, prenuptial does not, because prenuptial, the word nuptial, right, is marriage, right? So that is only related to division of assets upon divorce, not upon death. Yeah?
Yep. I understand the distinction there.
Yeah.
Ustaz, would you have any other practical considerations that you would like to weigh on this issue?
This is in terms of discussion with regards to prenup. I think for prenup, it is actually recognized in Islam. Okay, because we have ta'alik, because these are the things that we do, right? Before marriage, and we said, okay, so and so, if you leave your wife for a period of 4 months, then and you do not give any form of nafkah to your wife, then the first talaq will fall. Actually, it's an agreement between the husband and wife that I should not do anything. So prenup, if this is again discussion, again as what with what Cik Halijah has mentioned, prenup should be valid. If let's say the husband and wife has agreed upon what are the portions that the wife can receive monthly in terms of sustenance, in terms of nafakah, but if the husband states that the prenup goes after death, then the prenup will be considered as null and void, whatever that has been determined after death. Because after death, the law of Faraidh will fall. I mean, the law of Faraidh will be implemented. So if let's say they say after my death, the wife will get received, and if it's against the distribution stated by Islam, then it will be considered as null and void. And if he has not made any plans for other people that he wants to distribute again, for again what Cik Halijah has mentioned about the adopted children, and even now we have civil marriages. Civil marriages between Muslim and Hindus happen. Okay, so if let's say the husband has married a Hindu, and if let's say he passed on, wife will not, and if he has some, he wants to give away some of the portion to his wife, he's allowed. Okay, he's allowed regards to the will, the wasiyah. So and the wasiyah is 1/3 maximum, and if he wants to give the wife or the adopted children based on the portions which is fair for them, okay, the portion should be the same as the other children, then he should state that they should get an equal portion with all the other children, even though he's adopted, or even though the child is a child of out of wedlock. Okay, so these people these persons, they have no rights to receive, and they are not considered as the beneficiaries. Right? So if let's say you want to give away to all these persons, then you need to set aside certain monies based on wasiyah or based on wills. Yeah.
So now that we understand that Faraidh only kicks on upon death, for those who really want to try to limit the application of Faraidh upon their death, another question that I think comes to mind is whether or not you've seen cases where people then try to dispose of as much of their assets as possible while they are alive, so that a smaller proportion then of it falls to be distributed under Faraidh principles upon death. And if you've seen that, what are your comments on that approach?
Okay, there is this concept of hibah, gift, yeah, in Islamic law, as in civil law also, non-Muslim law, yeah. So for example, if I am, or say Ahmad, the guy we were talking about, right? Ahmad has got maybe a property, right? And he wants to ensure that this property, right, it is not if he dies, right? And I'm not talking about will here, right? If he dies, he wants to ensure that one particular child, say he has 3 children, okay, 2 are have done very well in life, can fend for themselves, they're lawyers, they're doctors, etc. But one child may not be doing as well as their siblings, and so he wants to give something to this child, right? So he has this property. What he can do, now assuming the girl is, or this child is above 21, because under our law, to hold immovable property, you must be above 21. He can add the name of this particular child into this property that he has. Either it's a condo or HDB flat. And hold it as joint tenants. Okay? So in that case, then, as Ustad has said, right? Upon death, right? The two sons will not, it doesn't, this flat doesn't fall within the definition of estate. And if it doesn't fall within the definition of estate, it will not be distributed according to Faraidh. So you can, this is part and parcel of estate planning, which is highly encouraged. So in this case, Ahmad will then put the name of his last child into this immovable property, hold it as joint tenants, so that when Ahmad passes on, his daughter will, by right of survivorship, his daughter will get the entire flat. Okay, so this is one example. Of course, there is if you have to remember, right? If it's a private property, when you do that, right? When you add in the name of another person, the stamp duty must be payable, yeah? Not so much for HDB, but if your property is worth 5 million, right? And the stamp duty is something like 3%, it does amount to a lot. So when we do estate planning, we have to be mindful of all these things. Yeah. Yes, you can. And again, to answer your question, you can in your lifetime dispose of your asset, right? You can say that, okay, I have 3 children. I have $5 million. I'm giving, before I passed on, right? 1 million to each child. Okay. So when I die, there's only 2 million. And only that 2 million will then be distributed according to whether it's Faraidh or according to the 1/3 will. So there are ways that you can do to sort of ameliorate or reduce perhaps the rigidity of the Faraidh laws. So another example of how you can do estate planning is, and I think Ustad has mentioned it, CPF monies. You know, in the bulk of our estate, for the normal people, the usual people, not the high net worth and all that, right? Is our HDB flat or our condominium and our CPF money. Almost everybody has CPF money. So what you can do is you can nominate whoever you want to receive your CPF money when you passed on. So you can give it to your adopted daughter, your adopted child, your stepchild, your illegitimate children, right? Your mistress, right? Whatever. So you can. My point is, or an aunt who is not a Faraidh beneficiary, your best friend, etc. So your CPF monies, which can amount to a substantial portion of your estate, that you can nominate. And once you nominate, it doesn't fall within the definition of your estate. So the minute it doesn't fall within the definition of your estate, then the Faraidh laws and the Muslim law of inheritance and distribution does not apply. Yeah? So it will go to whoever you have nominated in your CPF nomination form. Yeah? So there are ways. And another way, if you have extra cash, or even not extra cash, a lot of people have insurance policies in Singapore. And they are not just for health or medical purposes. Sometimes it's a life insurance policy. Sometimes it's endowment, which is some sort of saving. So the laws have now changed to say that if you nominate whoever is your beneficiary in your insurance policy, that the proceeds of the insurance policy when you die doesn't fall within the definition of a Muslim estate. So then Faraidh law doesn't apply, all that doesn't apply. So the insurance company will then hand over whatever is the proceed of the insurance policy to whoever is named as the beneficiary or the nominee in the insurance policy. It can be substantial, you know. I mean, insurance policy can come out to 100,000, 200,000, you know. So this is another way in which you can, people that, persons who are not the Faraidh beneficiaries, you can then identify and allow them to inherit your estate, your asset. the nomination of your CPF, nomination of your insurance policies.
Thanks,
Let me
Halijah.
add maybe a bit.
Yep.
When a person is alive, he is free to do whatever with his wealth. That is actually the Islamic law. Because I have accumulated the wealth, while I'm alive, I can do whatever I like. Okay, so I want to give away all my wealth to anybody, I can do so. But of course, a sane person, he knows that he needs this money for his future, for retirement and so on. He will never give away all his property. But I remember there's a case. There's the founder of Al-Rajhi Bank in Saudi Arabia. Okay, he's a billionaire. He has $1 billion. Okay, he was $1 billion and he decides to give 900 million to charity. Okay, 900 million, he set up a foundation and then he gives, and the 100 million, he has already distributed to the children. Okay, you are going to get this amount, which is quite fair based on Faraidh. All right, so everybody are going to get the proper proportions, and he has given away 900 million, and maybe he left a few millions for his own use. So it is okay. Okay, it's okay while we are alive to do whatever we like, and how much we want to give is okay. But if let's say you decide that this money is going to be distributed after your death, then there will be certain rules and regulations that you have to follow. Okay.
Thanks very much, Ustaz, for that. And before we move on to the second segment of our discussion proper, there are a couple of questions coming in from members of the audience that are quite helpful for us to wrap up with. And the first one being that now we go to the other end of the spectrum. What if the distribution under Faraidh completely aligns with how the deceased person intends to distribute his wealth? Would you then say that he should not put himself through the time and expense of doing a will, since it is completely aligned with Faraidh anyway? And the second question that I think would be helpful for us to address quickly is whether or not someone who is uncomfortable or unhappy with the manner of distribution, is there an avenue of appeal at all? Perhaps Halijah, you can start.
Okay, sorry, what's the first? Oh, the first question is if a testator, a person, before he passes away, he is very comfortable, and he's very happy that his estate is going to be distributed according to Faraidh. Like I give an example, husband dies, and then he leaves behind his wife and the son. The wife will get, I think, 1/8, if I'm not mistaken. The wife will get 1/8, and I think the sons, the two sons will get the rest, divided equally between the two, if there are two sons, right? So he's comfortable with this. Then that's it. There's no need to do anything. There's no need to do a will. There's no need to do a CPF nomination. I mean, he can put in his CPF nomination, my wife will get 1/8 and my two sons will get whatever is the balance equally. He can. There's nothing to stop him. There are a lot of Muslims who are very comfortable with distribution according to Faraidh. If that is the case, then there's no need to do anything, right? Because you in any event, you want your entire estate to be distributed according to Faraidh, right? So no need to do estate planning, except that for CPF, it is administratively, it is faster. You'll get the money faster if you nominate whoever you want to give your monies to, and if you want it to be according to the share in the Faraidh certificate, that's fine. Because otherwise, you'll have to take out letters of administration, etc., right? So if you nominate according to Faraidh, whatever your wife is going to get, your son is going to get, you put it in your CPF nomination, it'll be very fast. The beneficiaries will receive it quite quickly. So there's no need to do a will, right? There's no need to nominate who. I mean, if you have an insurance policy and you want the distribution to be as per the Faraidh distribution, you can put it in your insurance policy, right? Okay. So what is the other question again?
So the second question, procedurally, what if someone is just not happy with the way the assets are distributed? They are disgruntled about it, or they disagree with it. Is there any avenue of appeal against the distribution?
No, the concept of compulsory or mandatory heirs, HEIRS, or beneficiaries, right, according to the Faraidh, is fixed. If you're a Muslim and you're domiciled in Singapore and you die, domiciled in Singapore and you have estate in Singapore, the law says that you cannot get out of Faraidh. Okay, it's like I explained, right? In civil jurisdiction, Brazil, Switzerland, etc., right? You do have the concept of compulsory beneficiaries, right? I.e., the law doesn't allow you to disinherit certain surviving relatives. Yeah, so Faraidh is not unique to Islamic law. I just want to make that very clear, right? There are other civil law system which has this idea of compulsory heirs or beneficiaries. May not be 2/3, maybe half, maybe 1/3, etc. But the concept of mandatory heirs or beneficiaries is there. It's not unique to. So once you're a Muslim, and in Singapore, okay, I'm not very sure about other countries. In Singapore, if you are a Muslim, you do not have a choice. You cannot appeal. Yeah, you can do estate planning, right? But you cannot appeal. The Faraidh law is fixed, right? Yeah.
Okay, that is a very clear response. And Ustaz, would you have any final comments to add to these two questions?
Maybe one instance. Maybe I remember there's a case. Okay, but I do not want to talk about the rulings of that case. If just now Cik Halijah has mentioned about, if let's say the beneficiary is only for the daughter. If there's one daughter, and then the distribution will be given to the daughter as well as the Baitul Mal. Okay, so the Baitul Mal will receive a portion. But what happens if the daughter is handicapped? Okay, the daughter is handicapped and she requires the money and she is very young, and throughout her life she will need a lot of money, right? So Baitul Mal will receive a certain portion. In this case, they can the representative of this daughter who is totally handicapped, she needs the money, then they can make an appeal, and they have to go through the Fatwa Committee, and the Fatwa Committee will have to decide how much of the proportion from the Baitul Mal can be set aside or to be reduced. Okay, to be reduced, because at the end of the day is to help the needs of the family members in terms of distribution of health. And the Fatwa committees, they can change or they can reduce the amount with regards to the Baitul Mal should receive. Okay, so this I think there's some leeways in terms of extremely special cases. You can appeal, but whatever appeal should be done via the Fatwa Committee, because the Fatwa Committee has to discuss. At the end of the day, they might change or they might reduce the amount that the Baitul Mal. I think Baitul Mal is the only consideration. But if you talk about the other beneficiaries, I think there will be a term. There are certain level of unfairness. So in this level, Cik Halijah has mentioned there's no way for anybody to appeal or to change the distribution. Yeah.
So what Ustaz, just following on what Ustaz is saying, in certain cases, like I gave some examples just now, where there is no male heirs, yeah, a Muslim dies and he leaves behind his wife and a daughter. I said that in that case, right, a part of the share will go to Baitul Mal, which is the Muslim treasury. Now, Baitul Mal, they have the discretion. I have to emphasize the discretion, right, to give up, okay, part of the share. But that is totally discretionary, depending on the needs of the other beneficiaries. Okay, so for example, in this particular case, the wife, right, and the daughter are in really bad situation and they need the money. They can write to Baitul Mal, and then like Ustaz says, right, then Baitul Mal may want to give up part of the share. But that is only if Baitul Mal is one of the beneficiary. But if Baitul Mal is not, then Muis doesn't come into the picture, and all that lah. Yeah.
Okay, I think with that, this is an excellent segue into the next segment of our discussion, which touches on a very important topic on the tools for estate planning. Because now that we understand the principles on distribution of assets, let's think now about what are the tools we can use in estate planning. And Halijah and Ustaz, I think both of you have touched on this to some extent in our earlier discussions, where we talked about immovable properties being owned in things like joint tenancy. We've also touched very briefly on CPF and insurance policies. But I was wondering, Halijah and Ustaz, and perhaps Halijah, I can open this question up to you first. We have a number of, apart from the more conventional immovable properties, we have more complex properties, right? What about things like vehicles or jewelry or bank savings, which can also have, a huge amount of asset in them. Can you just take us through really quickly what flexibility or what tools we have at our disposal to plan these assets before death?
Okay, before I answer that question, it's actually the previous question. I want to explain that even though the Faraidh law, the Faraidh beneficiaries are fixed, right? Mother will get what share, father will get what share, son will get what share, daughter will get what share. There is nothing. The law doesn't stop the beneficiaries from discussing amongst themselves and agreeing that everybody will get a share equally. Okay, so for example, a mother dies, right, leaving behind 2 daughters and 2 sons. The husband has passed away, right? So the mother dies. Okay, so leaving behind 2 daughters and 2 sons, right? So under the Shafi'i school, right, the son will get twice the share of the daughters. But if these children, they are very amicable, they're very civilized with each other, and they said, no, it's okay, we don't want to follow Faraidh. We want to distribute our estate, our share equally. Sons and daughters will get equal share, right? There is nothing to stop you. Out of the goodness of your heart and all that, nobody is going to stop you, right? Because just because the Faraidh laws say that sons get twice the share of daughters, it doesn't mean that the parties, the sons and the daughters cannot agree amongst themselves to receive equal amount. Yeah.
Okay.
But the qualification is everybody has to agree, right? So it's quite difficult lah. If I am entitled to $10,000, right, and you are entitled to $5,000, am I prepared to give up my $10,000 and then share it with you? So if there are situations where the beneficiaries are agreeable to do so, of course you can do it. Nothing to stop you. Okay, and in fact, in some cases, and there are some case law on this about how they have this deed of family arrangement, right, to distribute according to whatever they think is fair, not according to Faraidh. Okay, just on that point, I wanted to say that just because Faraidh, it doesn't mean that the parties themselves cannot agree on what they want to. Like for example, right, the son is a well-to-do doctor. And right, and then the sister, right, is a disabled person. So he can give her all his share, right, or give her the same amount of share as he gets. He doesn't have to follow Faraidh. Yeah.
Okay.
But willingness and agreement and consent amongst all the beneficiary is required. Now I have forgotten your question.
So just very briefly, in terms of the tools of estate planning, so now we see a huge number of assets that people have these days, right? We have complex instruments. So apart from CPF, apart from the standard immovable properties, we also see things like vehicles, jewelry, bank savings, right? Those can constitute quite a significant sum of money. What would you say, very briefly, are some of the tools that can be used to maneuver some of the flexibility that the person has before death to apportion these?
Okay, let's talk about bank accounts, because almost everybody has a bank account. We all don't put our money under our bed, right? In tins and boxes. So bank accounts, right? You can have your bank account with another person and have it as a joint bank account. Yeah. Now, the problem with joint bank account is this, right? So if Ahmad puts in 90%, okay, there is $1 million in this bank account. The bank account is in the name of Ahmad and say his daughter, right? And Ahmad puts in 900,000, and there's evidence to show that Ahmad put in 900,000 and the daughter only put in 100,000. So generally, it's a little bit more complex here. Generally speaking, bank account, right? The default is the survivor gets the entire bank account. So the daughter will get everything. However, if there is a challenge, in other words, maybe the other sons, right? The other sons, the other daughter whose name is not in the joint bank account, challenges that, then it can be problematic. And then we will have to go into, is there evidence of what is the intention of Ahmad when he puts the daughter as a joint bank account holder, even though he is the person who contributed the bulk of the funds in the bank account. So one method, yes, you can put somebody's name as a joint bank account holder. However, bear in mind that it is nevertheless still open to challenge, right? So for example, like I said, 900,000 was put in, and there's evidence that 900,000 was put in by Ahmad, only 100,000 was put in by the daughter. So other beneficiaries may want to challenge that, to say that the daughter is not entitled to all the money because she only put in 10%. Okay, and then like I said, right, it will be litigated. What is the evidence of what is the intention of Ahmad? So while at first glance, yes, you can put in another person as a joint bank account holder. Yes, by default, the law of survivorship applies, but that's not the end of the story. Somebody can still mount a challenge to that. Okay, so it's not so simple. It's a bit more complex. Well, for jewelry and all that, right? Again, if the intent, if say a mother, right? A mother has all this jewelry, and then she made it clear that she wants to give it to the daughter, not the son. Why would the son want the female jewelry, right? Maybe that can be in the form of hiba, gift, Yeah. But okay, so far we have not had challenges in court about jewelry, about what's it? Okay,
Vehicles.
Vehicles is very clear. If it's in the sole name of one person, right? If he dies, it is subject to it's estate. So it's subject to the laws, which is you have to sell, right? So I have a car. Okay, I have a Ferrari, for example. I don't, but example, right? So I pass on. Then what happened to the Ferrari, right? Yeah. So because there's no will, for example, right? Then of course my Faraidh beneficiaries will take it, and then they have to sell the car and distribute the proceeds. Yeah, you can't chop up the car, obviously, right? You have to sell, and if there's a proceed, divide it according to the Faraidh. Or according to the will, if there is a will. Yeah.
Maybe I
Ustaz?
add a bit.
Perhaps you can share with us the practical challenges that we
Yeah.
can be mindful of when we
Okay.
implement.
When you talk about other tools, because when we talk about the default mode is actually Faraidh. That's the default mode. If you don't do anything, that will be that should be distributed with regards to Faraidh. But now we are seeing high net worth individuals, because in Singapore we are seeing people with hundreds of million dollars of wealth, and we have $1 billion Muslims. So these people are coming down and they want to plan their wealth. So the tools that they can do is actually hibah. Hibah is actually hibah is actually a gift. So you can, if let's say you have 5 children and one of them is very young, 2 years old, and the rest are already adults. I do not know why you have 2-year-old child, but the rest are all adult, and you want to protect this 2-year-old child. You can place an account under the child's name for his use in future. Okay, that's hibah. Or you can even give hibah amanah. Hibah amanah, that means you give to a trust so that the trust will implement the amount that you want to give to this child upon death. All right. So hibah, and we can also use hibah rukbah, which is actually recognized in Singapore. Hibah rukbah is actually hibah to give after death happens. Right? But you cannot do that hibah rukbah on properties as well as CPF monies, because these two properties cannot use other forms of instruments. Okay, but what other monies that you have, you can give hibah rukbah. And in Singapore is also recognized to do nuzriyah. Nuzriyah is still recognized. All right, so you want to do. And another tools that is coming up in terms of usage by the high net worth individuals, wakaf. Wakaf is to set up a trust, right? So you open up a family trust. Okay, you open up a family trust. You pump in certain amount of monies or wealth in that family trust for the usage of the family members, and you can place in this trust whoever you want to give your wealth for, or to get the benefits of this wealth. And so you can invest, and whatever monies you place back into that trust, and the individuals in that trust will benefit from the monies. So these are certain tools and that we are seeing. I mean, for me, as an advisor, people are coming down and they want to know what are the methodology that they can plan. Okay, so that there is a law of Faraidh you should follow, but you want beyond that. Okay, and maybe you want your future generation, you want your grandchildren to benefit from your wealth, and then the best way for you is to open up a trust. Okay, and you call it a family trust, a private trust. Okay, so these are some tools that I think people are coming out with solutions lah. Yeah.
Thanks very much, Ustaz. I think that's a very helpful point. And another issue that the audience seems to be very interested in, and it's a very topical one, is that of lasting power of attorneys. So the Office of a Public Guardian is promoting that Singaporeans do LPAs or lasting powers of attorneys. Is this something, Ustaz and Halijah, based on your experience, that aligns with Islamic principles?
Okay, before I answer that question, Ustaz mentioned something about nuzriyah. Yeah, I just want to point out, right, the issue of nuzriyah. Yeah, there is already a reported decision in Singapore which says that a nuzriyah in the Singapore context is not valid. Yeah. So we have to be mindful if we are going to use nuzriyah as a tool of estate planning, because in that particular case, which when was contested, what happened was, I think the testator, right, he had this instrument where he says 1/3 of my estate will be given to certain preferred relatives, one of his children or two of his children and some grandchildren, and then 1/3, he says, must be done according to Faraidh beneficiaries, and the other 1/3 to Mohs. So the issue is the other beneficiaries contested it, and they said that they don't contest the 1/3 to be given to the Mohs because that's allowed. Okay, but they challenge that 1/3 to favored. I can't remember how many children he has, but he says that this is my nuzriyah. I give one or two of his favorite children and one or two of his preferred grandchildren additional. Okay, and he called it a nuzriyah, but it has been held by the court that is invalid. Okay, so the portion, the 1/3 portion, which he says is the nuzriyah. A nuzriyah is basically a document which says that if I were to die 3 days or 4 days before my death, right, my asset will go to whoever I identify in this nuzriyah document. So that the High Court have said that it's not valid because so far in the Singapore context, because it's circumvented Faraidh. So we have to be mindful if you want to use nuzriyah. You can use it. However, be mindful that if a challenge is mounted, like in that particular case, right, the other beneficiaries, the Faraidh beneficiary says that, no, you can't do that. The two-third must be for the fixed Faraidh beneficiaries. The one-third to the mosque, yes, we understand. Because a Muslim is allowed to give one-third to whatever is the non-Faraidh beneficiary. The LPA, yeah? What is an LPA? We hear a lot about a lasting power of attorney. In simple language, a lasting power of attorney is a document, right, where I appoint someone, okay, to handle it's divided into two, my general welfare, in other words, if hospitalization, medical issues, where I live, and financial affairs, my bank account, etc. Now, why do I want this document? So now I am sane. I haven't lost my mental capacity, right? So now, while I am sane, while I haven't become demented and all that, I put in this document called lasting power of attorney. I appoint, for example, my husband and my son to be my attorneys, so that the moment I lose my mental capacity, then they will take over my affairs. So a lasting power of attorney, and is highly encouraged, because we are an aging society and all that, right? So a lasting power of attorney is very useful because while I'm sane, while I have my faculties, while I know what I'm doing, because I am still sound mentally, I indicate to the world at large, okay, who is going to take charge of my personal affairs when I lose my mental capacity. That is what is a lasting power of attorney. Now, the problem of not doing a lasting power of attorney is this. Why do you want, you can ask, why do you want to do lasting power of attorney? Okay, so I don't do a lasting power of attorney now, right? I'm still sane. I haven't lost my mental capacity. Now, supposing I have a stroke, okay? 1 year's time, I have a stroke, I become mentally incapacitated. Then who is going to manage my affairs? I've got bank accounts, I've got houses, I've got whatever, shares, right? And who's going to handle my general welfare? Who's going to decide what is my medication, what is my treatment, where I'm going to live, right? Then what happened? Because I don't have a lasting power of attorney, then somebody will have to apply to court to become my deputy. So my husband or my son or whoever, my sister, my brother, will have to go to court and apply for somebody to then take care of my personal affairs. It's problematic, right? You go to court, you know court is not cheap. You have to serve the papers on everybody, etc., etc. So it's better to do a lasting power of the attorney while you haven't lost your mental capacity. Do it. And it's very clear. Now, I still have my faculties, right? I make it very clear who I want to take charge of my affairs if I become mentally incapacitated. So it's very good to have it. And to answer your question, is it Islamic or un-Islamic? There is absolutely nothing wrong with it, right? Yeah. So it should be done.
Ustaz, do you have anything to add?
With regards to LPA, I think there is a fatwa that has been issued. Okay, with regards to lasting power of attorney, and the concept is actually the concept of agency or the concept of wakala. That means I appoint an agent to do certain things for me. So you can do wakala for many business transaction, and even to look after your beings. So the fatwa is there, and actually it is part of planning. Because anything can happen in our modern days. Accident can happen, anything, health issues, and now we have financial transactions, bank accounts, who's going to sign on our behalf in the hospital bills. Okay, so and I think for husband, they can appoint the wife and or the one of the children. Okay, and also the wife can appoint the husband and so forth. I think it's practical, and I think the government is promoting this LPA now. Okay,
Yes,
and
that's right.
I think LPA is actually basically free, right?
Yes.
Free now.
For now, the registration,
Free, right?
I think it's
Yeah, I
free.
think recently I just did it. Also, I appointed my wife, and my wife appointed me just in case anything happens to us. So it makes it easy. And before this, it was done for my parents, just in case anything happens to them. So yes, it is extremely encouraged.
Yeah.
Do it now. Don't wait, because once anything happens, then you are too late. Okay. So if you are mentally incapacitated, then
Mm.
what can you do now? Because the document is not there. All right. So yeah, definitely.
So just a quick takeaway, it's not only encouraged, it's actually also aligned with Islamic principles and
Oh, definitely. Yeah.
teachings. Okay, I think we are quickly running out of time. So in just very, very briefly, there is one question that's been gaining a lot of interest from the audience, and if I can invite maybe Halijah to just sort of a quick answer, is that what if your son is estranged? So presumably one of the Faraidh beneficiaries is estranged and is no longer in contact with the family. What happens to the share of that person? Is it redistributed, reallocated?
No, you can't. His share is his share. You have to look for him. Or if you can't find him, you have to put it aside in the bank account or something, because you never know, right? 5 years later, he might appear. So his share is his share. You cannot just because you cannot find him or unless he's dead, that's a different thing. Yeah, and you must have evidence of death, right? Yeah. No, you can't. His share is intact. Yeah.
Ustaz?
Yeah, exactly. Yeah.
Thank you. And with that, we are sadly out of time. It's been a very engaging session. And to wrap it up, I would like to invite each of our speakers to perhaps leave us with one key takeaway each. So, Halijah, perhaps you can start.
I think it's important to do estate planning, because the tools are there, and if even if you just have a HDB flat and CPF, right? It actually if you do estate planning, then you know that your estate, your assets will be distributed upon your death in accordance to your heart's desire and your wishes.
Ustaz?
Yeah. I think just as what Halijah has mentioned, planning is very important, and we need to understand our uniqueness in our family composition. So if let's say we have adopted children and we have illegitimate children, there's also cases, civil marriages, and then you have conversion happens in the family. You need to plan, and if you do not know how to plan, please get advice. Get advice from expert so that your future and your beneficiaries will be protected. Ultimately, you want your monies and your properties to be channeled to the people that you have worked your whole life for. Okay, so you have spent your entire life to accumulate your wealth. You want this wealth for your loved one. So please plan, and if you do not know how to plan, please get the proper advice. Thank you.
So just to sum it up, in today's day and age where we have modern families, we have different permutations. So like you said, Ustaz, we've got different some families where you have adopted children, illegitimate children. Sometimes not all members of the family embrace Islam. This type of planning in advance, it's practically beneficial and it's also aligned with Islamic principles. So I think with that, we have to close the session, and we're bringing the Q&A session to a close. If you found this webinar beneficial and would like to share it with your family or friends, the recording of this webinar will be made available on Pro Bono SG's YouTube channel in 2 weeks' time. The link will be dropped into the chat. So today we discussed about the issue of inheritance under Sharia law. If you know of anyone who is considering divorce under Sharia law, we have a webinar next Tuesday on 29 October at 7:30 p.m. Looking to explore the unique challenges and empowering strategies within the context of a Sharia divorce, unsure of how to navigate the intricate processes of the Sharia court, gain a comprehensive understanding of the Sharia divorce process in Singapore, and learn how to navigate it with confidence and resilience, even without legal representation. Join our moderator, Victoria Ho, and speakers, Ahmad Nizam Abbas and Zanaira Binti Saron, as they provide valuable insights into Islamic principles, legal rights, and emotional well-being during this critical phase of your life. Whether you're considering or already undergoing a divorce under Sharia law, this webinar will empower you to make informed decisions and embrace a brighter future. This and many more webinars are part of Law Awareness Weeks at CDC 2024. You can visit the website go.gov.sg/law-CDC or Pro Bono SG website or Law Go Where to register for this webinar or the many more webinars available. The links will be dropped into the chat function. At the end of this webinar, a survey form will pop up on your screen for your completion. We appreciate your comments as it will be useful to improve future webinars. Lastly, after today's fantastic sharing from both our panelists, and we find that you require legal guidance on your legal issue, do write to help@probono.sg. We would like to express our gratitude to Halijah and Ustaz Kamal for sharing your knowledge and your experience with us. It has been a very engaging and helpful session. With that, on behalf of Pro Bono SG, we would like to thank all of you for joining us today and have a good week ahead.